This document is a last will and testament of a person with a spouse and a minor child. A last will and testament, as you'll remember, requires probate in order to be given effect. So if you have other mechanisms in place for avoiding probate, you may avoid probate, but in the case of this will, with a minor child and the way that they own their assets, they will anticipate probate. So here in this first paragraph, we identified the spouse, the child, and then this provision provides direction to your agent in a different document on whether or not you will be buried or cremated and your individual decisions there. We get into specific gifts in Article 3. Tangible personal property passes to the spouse, and then as provided in a memorandum, and I'll point that out to you in a moment. First, additional specific bequest. We talk about homestead property here, passes to the spouse first, and then this particular will devises the homestead property into a trust for the minor beneficiary if under the age of 28. So depending on what you've decided, you may see similar language here. This gift also does include household contents and any interest in property insurance or anything that you have paid prior to your death. This second additional specific gift here confirms that you may have financial accounts that pass outside of probate by way of named beneficiaries on file with the banks. And if so, those supersede what you have in your will. So we're just confirming that that may be the case. And then here, this paragraph states that the vehicle is going to pass outside of probate to your spouse, and then in this case to a child, so long as they are 16. Article 4 is the residue or the catch-all. So that's everything else that's not specifically given away. It's going to pass in this circumstance to the spouse, and if the spouse does not survive, then to the descendants, and we see that per Sturpey's language, subject to trust terms if the beneficiary is not yet 28 years old. So I'll point out the trust for the kids here in just a moment. This paragraph here is what we call the remote contingent beneficiary. So if her spouse does not survive her and her children do not survive her, we have a paragraph allowing her estate to pass to more remote descendants, and you may make that decision in yours as well. But for minor beneficiaries, it's common to set up a trust. In the case of a trust that is contained in a will, we call it a testamentary trust. It means it comes into effect when you're gone. So here, the trust applies to any minor beneficiary under the age of 28 when they inherit. If they're under the age of 18, we've authorized broad distributions for health, maintenance, support, and education. And then after the age of 18, we will make distributions at the guardian's request to the trustee. Interim distributions are authorized. A third of the trust shall be distributed outright at 21, a third of the trust at 25, and the final balance at 28. The trust terminates when the beneficiary turns 28, and then of course the assets go outright. If the beneficiary if their death is the event that terminates the trust, then the assets in their trust instead pass to their descendants per Sturpey, so keeping it down the family tree, and if not, to the beneficiaries listed as your remote contingent beneficiaries. In Article 6, we get into personal representative and trustee nominations. So it's common to list your spouse in that primary role if you have one. If not, you'll see in succession the people that you have named. And the trustees may or may not be the same as the personal representatives that you've named. If they are not the same, it will be broken out, and subsection B of this article will be the trustee of any minor trust created in this will. We waive bond for our personal representative and trustee because we hopefully trust the people that we've named, and there's no need to require them to get that. Paragraph D talks about how a trustee can resign and what happens in the event of a vacancy. Paragraph E authorizes your personal representative and trustee to pay your final expenses, and it does entitle them to compensation recognizing that if they are inheriting from you, they may or may not take that. And that's a statutorily set rate. Paragraph F talks about what happens when multiple personal representatives are serving. So it gives them a little flexibility for acting jointly. And also we've got some language in here that shields them from installation if there are two people, or from liability if there are two people acting. Either one can act, and we're not going to hold either one of them liable for the bad acts of the other. This paragraph I says that if you do require probate in a different state, either the person you have nominated can serve or they can nominate someone else. And then paragraph J says that they can rely on legal opinion in carrying out their duties for you. If you have minor children, in Article 7, you'll name guardians for that child or children. Here, she's named her husband, and then in succession, if he can't do it, we've got a friend, and then if they can't do it, you can go on in a hierarchy there. And there's some language talking about how they serve without bond. We've got some administrative provisions starting in Article 8. The first one is a requirement that a beneficiary survive you by 30 days. Again, here in paragraph B, authorizing your personal representative to pay all funeral expenses and final expenses incurred with the administration of your estate. Paying your final taxes is included in what they can do for you. If you have minor children or a spouse that might need distributions during the administration of your estate, they're authorized to make payment to them. And we're not doing anything in this will that would otherwise thwart any support obligation that you might have. So we confirm that there. If at any point it becomes uneconomical to administer separate trusts, this would really apply, for example, in the case of minors. Paragraph F gives your trustee a bit of flexibility in combining trusts. And then paragraph G is a general power of appointment. Paragraph H says we are not violating what's called the rule against perpetuities. That means every trust that we have created must have an end date. The one in ours does, it's 28. And then paragraph I confirms again that you may have assets that are passing outside of probate by way of beneficiary forms. Paragraph J says, even though we are potentially moving real property into a trust for your minor if they're under the age of 28, we're not doing anything with regards to your homestead exemption. We're not changing your right to reside in the property. You still have all of those rights to do that. And then we get into a long list of powers that both your personal representative and trustee have in exercising whatever power it is that they need to do for you. So these are really broad. They may or may not all apply to you at this moment, but we leave them in just in case. And it includes similar powers to what you'll see in your power of attorney, which, as you know, is good during your lifetime. These are the powers that they have when you're no longer here. It includes things like buying and selling real property, accessing bank accounts, borrowing money on your behalf, investing for you, and a long list of items that they may need to do for you. Accessing digital accounts, we'll see that one again. And then we get to the notice requirement that tells your personal representative or your trustee how they can give notice. Here's a paragraph explaining how the principal and income may be allocated. And paragraph D states that a beneficiary is entitled to at least an annual accounting. Here we get into miscellaneous trust. So, for example, this trust here allows for treatment of stock as an S corp. So there's some flexibility offered there. We do build in a very generic minors trust. So this would not apply to direct descendants, but might apply to more remote descendants like grandchildren, great-grandchildren, and things like that. So we make that one a bit more flexible and a bit more generic than the one that we went over previously. Paragraph C is a retirement benefits trust. We build this in just in case you are leaving tax-deferred money to beneficiaries, to non-spouse beneficiaries. including this retirement benefits trust gives you a bit more flexibility in the way you may include them as beneficiaries of retirement plans. Then we get into some miscellaneous provisions, the first one being a spendthrift provision. So this paragraph here means that while you are alive, even though you have named beneficiaries in your will, their creditors, if they have them, cannot attach to your assets to satisfy their judgment. So once it goes out to them outright, it's fair game, but during the time that you're still alive or during the time that their trust is set up, it's hands off for judgment creditors. And then paragraph B just talks about the names of the trust in this document. Paragraph C defines descendants. Paragraph D defines discretion. Paragraph E defines incapacitated. We make a reference to what an independent trustee is. We reference the Internal Revenue Code that governs. We define heirs. We provide that Florida law governs, and then we have that definition of per stirpes. So we sign in the presence of 2 disinterested witnesses and a notary. And this document will live in your portfolio until it's needed. Like I said at the beginning, if you require probate, this is the document that the court will use in order to make disposition of your assets. And in the meantime, there's no need to do anything with this document. Just keep it in a safe place. The portfolio that you will receive, the original will be in a protective sleeve. And that's because when you pass away, the original will actually gets deposited on file with the clerk. So in a nutshell, that is your last will and testament.